The next question was asked by Gerard, and he says, if a residential property has been purchased and paid for in full, with the transfer costs having been paid, but now this all before taking occupation of the property, must the occupier pay occupational rent if the property has not been transferred to the new owner? Cilna, can we provide Gerard with some advice here?
Yes, definitely. So it's going to depend on who the occupant is. So when you gave me the question before we started, I thought it's like potentially another occupant. Where now that I've heard it again, see, it's because the generator's been long enough now. I do believe that the question from Gerard is, as the purchaser, you take occupation prior to transfer. Then definitely, yes, the occupational rent has to be agreed to in terms of the offer to purchase. Now, what we see, unfortunately, is that there isn't a proper occupational rent clause. And that's quite unfortunate, because very often the parties believe that occupation will only take place on transfer, and for that reason, they just leave it blank and it looks like there isn't occupational rent payable. In that case, unfortunately, there won't be. But if there is an amount of occupational rent recorded in the offer to purchase, and the purchaser takes occupation prior to registration, definitely, he will have that occupational rent. If, however, transfer occurs and the purchaser, the seller does not vacate, or for some reason the purchaser cannot take occupation, for instance, the seller still needs to evict the current occupant, then the seller is the party that will have to pay occupational rent. In the context of a random third party, so not overly random, say for instance, a tenant that took occupation, it depends on whose tenant it is, because you're paying occupational rent for the, wait for this, right of occupation. We all saw this one coming. So depending on the party that is using the right of occupation, that party is the party that will have to pay the occupational rent. So I see this often with investor purchases, where they purchase a property and already place a tenant prior to registration, obviously on consent from the seller. And in that case, the purchaser will have to pay the occupational rent agreed to in terms of the offer to purchase. He obviously then is entitled to the rent from the tenant in occupation of the premises, where he is now effectively the landlord, already just waiting for transfer. So occupational rent is a very handy thing. I actually recently had a matter, a new instruction, where an eviction was granted already in 2018, and the occupant took occupation again after the sheriff executing the eviction order. And that was luckily on the back of a sale. And it's family members, again, from a deceased estate, that's why I'm thinking about this, from a deceased estate, the family members are sort of having a fight between each other, but they had the benefit already of the sale to them, and they received the money from the estate, but it's now one of their family members that refused to vacate the premises. And what I'm advising the client currently is that we can actually now hold the family liable for the occupational rent all the way from transfer, which was January 2018, up to where we are now. And considering the purchase price was 300,000 Rand, this is already running up on the occupational rent. I think it's about 3,600 Rand a month. So it's running to around 160,000 Rand by now. So, I mean, that's more than half of the purchase price. And that's motivating a little bit. So occupational rent isn't just handy in the context of investor. Record your occupational rent properly, because in the case where you are the purchaser and you can't take occupation and the seller was supposed to give you vacant occupation, up to the point of where you can actually take occupation, you are then entitled to claim occupational rent from the seller, which is quite a handy thing. Tip on the side is obviously, if there is a case like that, make sure you ask the conveyancer to hold the money on trust until you are in a position to take occupation, because you are entitled to occupational rent up to that point. So I hope, Gerard, I answered your question there. I think I answered 15 other ones that you didn't answer. Wait, ask, not answer, I answered.
Thank you, Cilna. I'm going to move along now to a question for Bruno. The question is from Neo. She says, a home was just purchased at a sheriff's auction. The buyer wants to pay the family living in the property 10,000 Rand to move out, to vacate. She says, isn't there at least notice that the family should be served with, which will also provide them with sufficient time to find alternate accommodation?
Sure. So I suppose if we get to the bottom of all of this, there is no obligation on the purchaser to pay anyone 10,000 Rand. So insofar as timelines are concerned, this is completely between the parties. This isn't about necessarily rights and obligations and duties and even legislation. If I enter into an agreement with you that happens to benefit you, it benefits me, I give you money, and you move out the property, and so be it. There's absolutely nothing wrong with that, and there's no apparent contravention of any human rights or anything of the sort. So if the purchaser wants the 10,000 Rand, then ideally either they adhere to the terms under which the 10,000 Rand is paid, or they try and negotiate better terms for themselves and adjust the amount of money that's being paid. It is very you could say generous of a purchase. So it depends on the purchasers. Some purchasers do this quite often, where they'd rather offer money to get the people out. Some of them do it quite generously, and it's something that we need to bear in mind. So some purchasers actually put together like a nice little package going, we'll help you move out. We've got moving trucks. We'll even pay a deposit for you to move somewhere else. Yes, it's not completely selfless, but it's done because at the end of the day, sale and execution does ultimately result in normally the previous owner of the property losing ownership and losing rights to that property. And there's nothing in our law that states that there needs to be any form of notice period. Remember, it's only when you get to the court that the court considers certain factors and grants an order based on those factors, and that might involve a time period. And sometimes the guys that buy the property on auction would do the same thing even ahead of time to say, look, this is what the court's going to say, so I'm affording you A, B, and C. I'm giving you the opportunity, because then by the time they get to court, even the court at that moment would consider the fact that certain indulgences were granted. So yeah, to answer the question, there's no rules around this. This is just negotiation between the parties. On the side of the investor or the purchaser, they're doing a generous thing. So there's nothing wrong with it. On the side of the occupier or the previous owner, so obviously if you feel that your rights are being infringed, it's a different story. Then seek representation if there's more to the story that we haven't heard. But if it is simply a offer of money, it's your call, your prerogative. But then you want the money, you're going to need to adhere to what the purchaser requires.
Thanks, Bruno.